Good evening, everyone, and welcome to tonight's panel discussion on Senate procedure, minority tools in the judicial nominations process. My name is Voruganti. It's my privilege to be moderating tonight's session. I am also serving as the president of the DC lawyer chapter of the American Constitution Society, which is the primary sponsor of this event. I am really excited to be moderating this panel among three incredibly knowledgeable individuals. And I think we're gonna have a really productive discussion this afternoon. And so I'm gonna not talk too much and let them do the talking. I do want to acknowledge, I wanna give our thanks to ACS National as well for setting up this event, as well as all of our lawyer chapter co-sponsors for assisting us with broadcasting this event, as well as for watching. At the end of the event, I will do an individual shout out of every sponsor, but let me jump really quickly to our panelists as a brief introduction of each. In no particular order, I'll start with Leslie Proll. So Leslie is a civil rights lawyer. She's currently advising the NAACP on judicial nominations. Previously, Leslie headed the Civil Rights Office for the Department of Transportation under President Obama. She's also served as years for as the Director of Policy for the NAACP Legal Defense Fund. In her experience, she's worked on scores of judicial nominations. She has experience on both Supreme Court and lower court confirmations throughout the Clinton, Bush, Obama, and Trump administrations. And the current nomination process is actually her 10th nomination to the Supreme Court that she is working on. So Leslie is a veteran of this process. We are also joined by Alan Fruman. Alan comes to us as the former chief parliamentarian of the US Senate. He has served over 35 years in the office of the Senate parliamentarian, and he was the chief parliamentarian for the majority of that time. In fact, Alan has a record for being the second longest serving chief parliamentarian in US Senate history, as well as being the only person to be promoted to the position of chief parliamentarian by each political party. And that really speaks to, I think, both the knowledge and the expertise and the respect that Alan Fruman commands among scholars of the Senate for his knowledge of Senate parliamentary procedure. Finally, we have Adam Jentleson. Adam is the Public Affairs Director at Democracy Forward. Prior to joining Democracy Forward, Adam also served as Deputy Chief of Staff to Senate Democratic leader Harry Reid, working for him both when Democrats had the majority and when they had the minority. In this role, Adam advised Senator Reid on political, legislative, and communication strategy. And as such, he has over a decade of experience working on the intersection of policy, communications, and legislative strategy. He himself has also sat through a fair number of confirmation fights. So between the three of them, there's really a plethora of knowledge on this panel. So I think all of us are in for a treat. So before I start the planned questions, I'd like to turn it over to the panelists to see if they have any opening remarks. And let's go in reverse order from where I did the introductions. So Adam, would you like to go first?
Sure, and I just wanted to say thank you, Hirsch, and thank you to ACS for hosting this event. It's incredibly topical. I'm thrilled to be joined by my fellow panelists, and I think it will be fun and interesting to reprise the dynamic that happens so often in the Senate, where people like me come up with ideas and people like Alan tell me that they're wrong. So that is something that I've enjoyed. Something about the Senate that I enjoyed the most was actually working with the parliamentarian's office, working with the folks in the cloakroom and the floor staff, who are sort of the floor staff is sort of the intermediaries for each party between the parliamentarian and leadership of each party, but spending a lot of time sitting in the cloakroom working through difficult parliamentary issues and trying to come up with ideas for how to push back and advance our side's cause in situations like the one that the Senate is currently facing was a big part of the job, and something that I found particularly interesting and rewarding when I was there. I'll be really brief in opening because I know folks want to get to questions, and I would just say broadly, if addressing the topic of tonight's discussion, that the minority's tools for blocking Supreme Court nomination at this particular stage, both in the life of the Senate and in this exact political moment, are very limited. By definition, the minority will not have the votes to block a nominee. The reason that that's the case now is that when Gorsuch was nominated, Republican leader Mitch McConnell used the nuclear option, which my former boss, Senator Reid, had used in 2013 to lower the threshold for confirming Supreme Court justices from the 60-vote threshold, which was not the threshold for actual confirmation, but rather the threshold for clearing a procedural hurdle in the process of confirmation called cloture, which is something we can talk about more if folks are interested in discussing the ins and outs of cloture. But anyway, the nuclear option, in a nutshell, made sure that there is no supermajority hurdle, no hurdle greater than 50 votes on a nominee's path from nomination to confirmation. When Senator Reid deployed the nuclear option to do the same thing, he did it for all nominees except Supreme Court nominees. So all executive branch nominees and all judicial nominees except Supreme Court nominees. So by definition, if you're in the minority now that the threshold has been lowered to a majority for confirmation, by definition, the minority does not have the votes to block. What they can do is they can do two categories of things. They can use procedural options to gum up the works, to essentially demonstrate that they consider the nomination and the process to be illegitimate, or to at least one step short of illegitimate, that they have grave concerns, that they think there is something fundamentally wrong with the process. They can use these tools to make this process different than any other process that has come before it. And we could talk more about why that's significant later, but I just want to establish that category. And the second category is applying public pressure, essentially political pressure, to flip votes and to get the votes to confirm. That category, I'm sure will come into the discussion, but it's essentially, messaging. Democrats have decided that the most effective messages against Barrett in this situation are the likelihood of repeal of the ACA if she's confirmed, and the likelihood of Roe v. Wade being overturned and abortion being criminalized. But that second category of applying public pressure is essentially, traditional political messaging, holding news conferences, going on TV shows, using social media to drive your message. The interesting thing about that category, though, is that is what allowed Democrats to win a fight over a majority vote issue. It wasn't a Supreme Court battle. It was the repeal of the ACA in 2017. But, they didn't use anything pulling rabbits out of their hats procedurally on the ACA. They just beat Republicans by winning the political battle. I think the incentives here are a little bit different. Republicans are more committed to Barrett than they were to repeal, but that's another story. Back to the first category really quickly. We can get into these in more detail later, but the types of things Democrats could do to use procedural tools to gum up the works include refusing courtesy visits that the nominee traditionally holds during this process. Leslie can talk a lot more about this and the precedent for that. Boycotting the hearing, boycotting the markup, which is when you vote on the nominee. That's a separate process from the hearing itself. Those are things that happen in committee, as Alan can describe. Committees in the Senate are sort of independent entities. So that's in committee. On the floor, which is a separate category, they can object to what are called unanimous consent agreements, which are essentially sort of all-encompassing agreements that majority leaders use to run the Senate on a day-to-day basis. These came out of rule changes in the 1970s and 80s when the workload of the Senate was growing, the job of the majority leader was extremely difficult, and they pioneered these unanimous consent agreements to basically allow the majority leader to set everything about the way the Senate was going to run on a given day, from the time votes would be held, to the conditions of the vote, and all those things. That's the beauty of unanimous consent agreements, is once they're locked in, they control everything that the Senate does. The downside to them is the unanimous part, which is that it requires every single senator to agree to them, or at least for no senator to object. And achieving that is often very difficult. So if you decide to object to unanimous consent agreements, you can do a lot to gum up the daily workings of the Senate, especially if the other side has things they want to move along during that period. They can force what are called live quorum calls. I wrote a piece recommending that they do this. That is when a single senator can note that a quorum is not present on the Senate floor. A quorum in the Senate is 51 senators, which technically have to be present for the Senate to conduct any business. It is routine now for the need for a live quorum to be present to be waived. So the Senate conducts all sorts of business with 2 or 3 senators on the floor. But if, again, it's waived by unanimous consent, so if one senator objects to the waiving of the quorum call, and they note the absence of a quorum, the Senate is then required to produce a quorum on the floor before it can go ahead and conduct any business. So that is something that can be very disruptive. I do think the calculus on that one has changed a little bit now that we know there's a COVID outbreak racing through the ranks of the Republican conference, especially with senators refusing to get tested, like Senator Grassley and Senator Graham, forcing Republicans before. I think the dynamic of that changes when it's possible that several of them have COVID and refuse to get tested, but that's a side story. So those are some of the options available to Democrats. They can do things like object to the 2-hour rule, which essentially makes it forces committees to meet in the 2 hours from when the Senate convenes until 2 hours from then, and other things like that. But the upshot of the purpose of all of these tools is to demonstrate that they think this process is wrong, is illegitimate, and should not go forward, and hang an asterisk around it and say this is fundamentally different from anything that's come before. And I think that what I'll close on is just saying that I think is, if the minority doesn't have the power to block the nominee, the power to brand the process a certain way is still very significant. Essentially, a way to think about it is, when the final stories are written about this process, or is it described as a contentious battle over the nomination, which is something that is basically routine at this point, or is it described as unprecedented, and is it described as something that hasn't happened before in the history of the Senate? The reason that I think something like that matters is that we are finding ourselves at a unique time right now. We have a president who is elected by a minority of the population. According to the rules, there was nothing untoward about the method of election, but the fact of the matter is that he represents a minority of the population. We have the Senate controlled by a majority of senators who, when you add up all of the populations that they represent a minority of the country. You've got 2 of the Supreme Court justices currently sitting on the court, representing a minority, or nominated by a president who represents a minority of the population, and confirmed by senators who represent a minority of the population. So we are facing something of, I wouldn't say a full-blown legitimacy crisis, but definitely a situation that is probably not sustainable or healthy for democracy in terms of elected officials who represent a minority of the population making decisions that bind the majority. And the Supreme Court is, of course, at the center of this dynamic. With the margin this small, you never know. This is going to turn on a couple of votes. So it's entirely possible that using all these tools, Democrats are able to flip 1 or 2 votes. It's possible that there's a crisis of conscience. It's becoming very, according to the polls, it looks like Trump is headed for defeat, but that could go either way in terms of changing the incentive calculus for senators. So maybe, deploying all these tools applies enough pressure that some votes flip. If that doesn't happen, deploying all of these tools, doing it aggressively, will nonetheless have the effect of demonstrating that Democrats found this process to be fundamentally different and objectionable in a way that no other Supreme Court confirmation process was. That then lays the groundwork for the reform that's going to be necessary if Democrats take back the Senate and the White House to address this fundamental imbalance that we're seeing as a democracy right now. So I'll wrap up there. But I think, the point I just want to make in opening is that the tools to actually block are limited, but the tools to demonstrate in actions and not just words, but to demonstrate how Democrats feel about the process is pretty powerful.
Thank you, Adam. I'll turn next to Alan Freeman if you have any opening remarks.
Thank you, Harsh. Thanks for inviting me to participate in this panel. And thank you for giving me the opportunity to spend some time with former Senate staffer, the few, the proud, the people who have put up with the vicissitudes of the Senate over the years. And it's good we could drag Leslie into this bit of turmoil as well. What to say? Adam was reminiscing about all the time have told you no. And for better or for worse, that's a large part of the responsibility of the Senate parliamentarian, is to tell people you can't do what it is you want to do. Every now and then we get to say yes, and that can brighten our days, but that's the exception and not the norm. I'm here basically to answer questions that the panelists might have going forward with respect to this nomination, as well as answering questions from your other viewers. I will say, though, in terms of perspective, the Senate over the years has been designed to act slowly and to take its time. And people are familiar with the filibuster. And people are familiar with the fact that in most instances, there are two filibusters available. There's the filibuster on the question of going to a matter, such as an Appropriations Act, let's say. And historically, there's been a filibuster on the question of voting on that matter. The problem that you folks are facing is those two filibusters, those two areas where the minority has been protected over the years, those walls have come down. And they've come down through a series of decisions made by majority leaders of both parties. Initially, the filibuster with respect to going to a nomination was taken down by Robert C. Byrd, Democratic majority leader, in several steps in 1979 and 1980. And so the first barrier to rushing to a nomination ended as a result of Senator Byrd's frustration with the Republicans back in the late 70s. The next barrier, as Adam well knows, occurred under his boss's watch, the nuclear button with respect to all nominees other than those to the Supreme Court. And I don't think you had to be have a crystal ball to realize that once that door was opened, the one exception that Senator Reid left would disappear as soon as it was convenient for the next majority. And Senator McConnell was only too happy to extend the nuclear option to Supreme Court nominees, meaning that the two areas where the minority party was protected against a rush to confirmation, those barriers have been taken down in successive steps over the last 40 years. And so you are facing now a situation where your procedural options are, shall we say, quite limited. So that's just a brief outline of why we are where we are. It's not the parliamentarian's role with ideas to, shall we say, gum up the works. However, other clever people sometimes can come up with those ideas. And so I'm here tonight to basically sit and listen. I'm not going to filibuster. I've really spoken more than I plan to speak. I think you are, I've defended the filibuster over the years. I've certainly defended both the judicial and legislative filibusters. I am sorry that the Senate is facing this situation. And if there are clever folks who have, shall we say, a plausible procedural way around it, I'm certainly willing to listen.
Thank you, Alan. And I would turn to Leslie next.
Sure. So thank you Harsh and ACS for inviting me. One of my favorite things to do is to talk to lawyers about judicial nominations. So glad to be here. I think I'm kind of invited to represent the advocacy viewpoint. So I'm coming at it kind of from the Judicial Nominations Coalition. We lobby senators. We do so from a nonpartisan organization standpoint, but we're the ones pushing Adam, who then goes to Alan, to try to do the things that we want to do to get fair and independent and diverse judges. I just wanted to kind of set the stage a little for what we're dealing with and kind of why we're all on at 7 o'clock at night before the debate, and why this is important to us, why we're so frantically looking for tools. You heard about healthcare and reproductive choice. The stakes are exceedingly high on a lot of issues: voting rights, affirmative action, LGBTQ rights. There is so much at stake with this nomination. That is because it was Ruth Bader Ginsburg who unfortunately passed away, and setting up the specter that we could have a 6-3 court majority, conservative, very, very right-wing court majority for the foreseeable future. So this is kind of a real alarm in terms of the stakes and what could happen. I would argue that it maybe even requires more of a rigorous process, because there is so much at stake because of who you're replacing, and to kind of have this condensed and truncated is, this is exactly the time that you would not want this to happen. I also want to point out is something that the civil rights groups are definitely talking about all the time. This is happening during an election, not just before an election. The voting started on September 4th when North Carolina sent out its ballot. So we're talking about the first nomination to ever occur during an election. There certainly have been nominations over time where you've had vacancies during presidential election years, and certainly most famously the Scalia vacancy that occurred in February of 2016. And over time, you've also seen some others. We looked back, and I think the latest we saw a Supreme Court confirmation was in July of a presidential election year. So this is just extraordinary that this is happening. I would also point out that something that I have never seen is where you have a majority of the senators saying they have the votes to confirm even before a nominee was announced. I have never seen that happen before. I also have never seen a president kind of talking aloud about why he wants a quick confirmation so that this person could potentially sit in on some election decisions regarding the presidential election. So that is also unprecedented. So just want to end with, there's so much attention with the president's nomination of a person to serve, but the Senate has a co-equal role in deciding who is appointed to the court, and what it does now ends up affecting the legitimacy of the court. And in fact, about 20 former federal judges wrote a letter to the Senate asking them to exercise restraint for that very reason. And they had this great quote, the legitimacy of the Supreme Court is not something that can be recovered if it is lost. So I just, I want to have this, conversation with, everybody thinking about why we're fighting so hard to think of all these tools, and why it's so important that we have a rigorous review, full review, comprehensive review of this nominee's record. Thank you.
Thank you, Leslie. And I think that's actually a great segue to my first question, which is kind of looking back. And I think when you're talking about the current process, it's often useful to do a compare and contrast, so to speak, to what's happened in the past. Now, as a kind of a distant observer of this process, what I thought when the vacancy initially opened up with Justice Ginsburg's tragic passing was that with 6 weeks until election day, there simply wasn't enough time to process the nomination through at least what's been the traditional process that I've seen of Supreme Court nominations. But somehow the timeline has been extremely truncated in an effort to fit it into the space. And given your experience, Leslie, with 10 Supreme Court nomination fights, your experience on the Senate, Adam, and as well as yours, Alan, can you speak to where are the corners going to be cut in order to fit all of this into this space? I think one thing that's already come up is in terms of the thoroughness of the disclosures to the committee. That's already been in the news. But how do you see the process functioning on a truncated level? And is it still possible to have a thorough process, at least at the, either at the committee level or on the floor level, in this timeline? I think you have to go back to John Paul Stevens to find a nominee who was confirmed within 6 weeks, but it was done back then. So basically looking back, how do you think it'll go and what differences will the timeline make? And I'll let any of the panelists jump in at this point, but I know that Leslie and Adam in particular, given your history, will have some thoughts on this.
I can take a stab. So, I think it's fair to say that usually every point of the process is kind of done with much deliberation, careful consideration, even the time period between the vacancy and the nomination. There's a kind of a, even if it's just a pretense, even if an administration knows who they want and has been thinking about it, there's a time lag. So it looks like they're considering who was serving in the seat, who should we put in this seat, let's talk to them. All of this, of course, was sped up very quickly. We heard, Judge Barrett came, to Washington, was called almost immediately after Justice Ginsburg's death. So, nomination to hearing is, I think I looked it up, usually 7 weeks. Here it's going to be 2 weeks. I would say, flatly, that's not enough time. And the example that I give is the nomination of Judge Barrett was formally sent up to the Senate on Monday after the Saturday she was nominated. And the very same day, she sent up to the Senate her answers to the Senate Judiciary Committee questionnaire. Now, if you unwrap that a little, usually the Senate gets the nomination. The Senate Judiciary Committee on both sides decides what they're going to ask the nominee in this written questionnaire. It's the questionnaire that asks for everything she's ever written, her opinions, speeches, video recordings, and so forth. It's a very kind of fulsome operation. And in this instance, I don't even know how they decided what was going into the questionnaire, but by Monday she had gotten the questionnaire and actually returned it. And you alluded to, I think, some missing documents. I mean, that is kind of the byproduct of doing this in such haste, is that it's already come out that she has failed to disclose a letter and an advertisement that she appeared in, talking about how Roe versus Wade was a barbaric decision, and that didn't show up in that questionnaire. And so it's very important that the Senate have everything available to it and be able, frankly, to have enough time to review things. I was reading an unpublished opinion tonight that I had never seen before. And so there are all these things that take time that we're just seeing them whiz by. And I think the American people are the ones who are going to be deprived of kind of the opportunity to fully vet her through the senators. And so I think, it's a disgrace. It's something that's been set up to move very, very quickly for a very particular purpose. And that is, I think, to deny some of the Senate at least an opportunity to do its rigorous scrutiny that's required under the Constitution.
Yeah, I mean, I'll pick up where Leslie left off. I mean, I think, you know, I think what we're seeing is not whether, you know, what's a reasonable amount of time for a proper vetting of a Supreme Court nominee and for the Senate to perform its constitutional duty of advise and consent. What we're seeing is what is the minimum amount of time you can ram through a Supreme Court nominee in a power play. I mean, that's, you know, I think ever since Garland, it's become very clear sort of any pretense of the process being about vetting a nominee, considering their views, having senators of both parties consider possibly switching a party, switching over and voting for them, even though that did happen on Kavanaugh and Gorsuch. But this has fundamentally become about power and about politics, and even some of the bipartisan switching, I think was largely a political calculation. So that's what's going on here. I don't think there's any pretense that it's anything different, and I agree with Leslie's flat no that it's not enough time to adequately vet a Supreme Court nominee for a lifetime appointment, but that's just not the game that's unfolding.
So let me pivot off of that a little bit. So one of the questions that we get a lot, and at least this is in the public consciousness, is the idea that the Senate is a body that runs on relationships and norms, and essentially that there's a sense of comity between the senators on there are certain procedures and ways that things are done. There are traditions that the Senate is very respectful of, and that I've heard the metaphor of the House is kind of the pot that heats up the tea, and the Senate is the kettle that, the saucer that cools it down. That it's intended, I think, as Alan mentioned in his remarks, to be a place where things slow down. So how much of this, and I want to direct this at Alan, given the length of time and experience that you have, Alan, of how much of that is just kind of a public perception, and how much of that is true, that the Senate really is this slower, more deliberate place?
Well, over the years, I believe it was true. And as I said, when somebody comes to the Senate to work in the parliamentarian's office, you inherit the history and the tradition, the culture and the mores of a place that works slowly and only works through bipartisan consensus. And I'm a child of the 60s. My initial recognition of the Senate during the 60s was that it was the place where civil rights legislation went to die. And so from that perspective, the Senate way of doing business was not something to be lauded. When I went to work, shall we say, the last diehards who were opposing civil rights legislation were there, but there were fewer and fewer of them. The customs and the mores of the Senate in requiring the minority buy-in were still there. And yet the damage that could be done by those who oppose civil rights was lessened simply by natural evolution. And so to a certain extent, for me, I was coming to work at the Senate during a sweet spot in its history. The dreaded reviled filibuster that dashed civil rights legislation for generations was still in place to help the minority, but the minority was no longer fighting a rear guard battle against civil rights. And what the filibuster showed me, and especially what it showed a lot of Democrats in 1980 and 1981, themselves in the minority in the Senate for the first time in 24 years, was that the way the Senate did its business was not a bad thing, because the Democrats had some protection. And I mentioned before in my opening remarks the dreaded filibuster, the debatable motions to proceed to matters, as well as the fully debatable questions on adoptions of passage of bills and confirmation of nominations. All of those things meant that the minority had some buy-in and that nothing got done without the minority participating. It would be a terrific thing if the current Senate minority had some buy-in with respect to this nomination, or for that matter, with respect to several previous nominations. As I said, I watched in 1979 and 1980 when the first filibuster on the done away with by successive points of order by the Democratic Majority Leader Robert Byrd. I understood the impetus behind that, but nonetheless, that one wall of protection came down. And I watched throughout the aughts as the confirmation battles raged between the Senate Democrats and George W. Bush and his nominees. And I saluted the Gang of 14, who in 2005 came up with a compromise, saved the filibuster on nominees with a promise that the process wouldn't be abused and that the nominees wouldn't be out of the mainstream. And so those mores held. The Gang of 14 was a group of 7 senators from each party who were not in the leadership. That was Senate at its best. Rank and file members, spearheaded by John McCain, who said, we need to preserve the minority's rights here, but we also need to ensure that the minority is not being asked to swallow radical nominees. And again, as Adam knows, Senator Reid in 2013, who was faced with, I believe, an unprecedented level of obstruction. People have asked me over the years, don't you disagree with what Senator Reid did? And I give, in a sense, a bifurcated answer. I tell people that Senator Reid faced unprecedented opposition and obstruction, and especially with the DC Circuit Court of Appeals, when the Republicans made it clear they didn't really oppose nominees individually, they opposed the idea of filling vacancies. And so Senator Reid had to do something. The question was, did he do too much? Did he go too far? And I think he opened the door for Mitch McConnell to, on the very first filibuster of a Supreme Court nominee, to pull the nuclear trigger. So I think Harry Reid was adequately provoked. I think his response to that provocation was overly broad. And Mitch McConnell, at the slightest level of provocation, extended the Reid precedent to Supreme Court nominees. So I think, yes, I think comedy, I think the Senate's culture, its way of doing business over the years, as evidenced and epitomized by the Gang of 14 saving the filibuster in 2005. In 2013, in the safety of retirement, I asked, is there a Gang of 14? Is there a Gang of 10? Is there a gang at all? The answer was no gangs this time. And for the first time in my life, I was sorry for the absence of, in a sense, gang warfare or gang peace.
So let me use that to kind of pivot to tactics that are making their way around the media, because this is a popular topic. You know, when our team got together to start discussing how to put together this panel, at around the same time, we had 4 or 5 different media articles come out, I think including yours, Adam, of potential tactics that that senators in the minority could use for blocking a Supreme Court nomination. And there are a lot of tactics that are included in there, particularly ones related with unanimous consent and essentially dealing with the quorum process that you described in your opening, Adam. So let me put it out there, since all of you have so much experience with both the Senate and the confirmation process. What do you think of the ideas being circulated? I mean, I'm going to assume, Adam, that you endorse the idea that you put forward. But what are your views on some of the ideas that have been proposed? What do you think about extensions of calling extra quorum calls, using a speaking filibuster, and ideas of such nature? And I'm happy to throw it to whoever wants to take that question.
I'll take it. And I think before I answer your specific question, I just want to offer a slightly different view with all extreme respect to Alan, who is unmatched in his experience and perspective on the Senate. But I look at it slightly differently, which is that the filibuster is not the Senate. The answer to your question, does the Senate operate on comity? Has it traditionally operated on comity? Does it rely on that to perform its unique function of slowing things down? The answer to all those questions is yes. However, I think where I would offer a different view is the idea that the filibuster promotes any of those purposes. And I think it's important to go back in history here and understand that the filibuster is essentially a procedural mutation that came about through a series of changes and innovations and tactics and approaches, and frankly, a harnessing of a lack of comity, primarily on the part of Southern senators in the Jim Crow era, and turning it into the 60-vote threshold that we know today. But just to sort of level set here, it's important to be absolutely clear that the way the Senate was envisioned was as a majority rule institution, and there's not much debate about that. It simply was a majority rule institution when it was created, and existed as such for the first century or so of its existence. The filibuster started to come into existence towards the middle of the 19th century, but even then, it wasn't a tool that allowed anyone to elevate the threshold for passage higher than a majority. It was pioneered by many different senators, and not just Southerners and not just conservatives, but was wielded primarily and was innovated primarily by people like John Calhoun on behalf of the slave power and the South, when they sort of saw themselves becoming outnumbered by the march of progress and the growing power of the Northern economic model and westward expansion, obviously, which was I don't have to tell you guys, it was a huge issue. It led to the Civil War. So when the filibuster started to come into existence in the 19th century, it was the talking filibuster of Mr. Smith goes to Washington. There was no ability to raise the threshold for a vote. The vote to pass whatever bill was being filibustered was still a majority threshold, but senators stood on the floor and talked and used a lot of different dilatory tactics like filing amendments, things like disappearing quorums, a bunch of things that have been eliminated by reforms. But fundamentally, the challenge was to use talking, to use dilatory tactics to delay as long as you possibly could. And eventually, it would be exhausted. Whatever the bill was at stake would come up for a vote, and it would pass or fail based on a majority vote. There's an example in 1946. There was a bill before the Senate to organize a territorial government for the Oregon Territory. Southerners were filibustering it because the bill outlawed slavery in the territory. John Calhoun was part of this filibuster. They filibustered until the proponents of the bill were able to demonstrate that they had a majority in favor of the Oregon Territory bill. And at that point, a bunch of the Southerners who were filibustering the bill basically said, okay, time to yield. And this was not sort of a newsworthy statement at the time. It was just them representing the ethic of the time, which was the minority could filibuster, they could delay, but if at the end of the day, it was appropriate and in keeping with the traditions of the Senate for the minority to yield to the majority. And there was a funny sort of exchange where John Calhoun's fellow filibusters all said it was time to yield in keeping with the traditions of the Senate, and Calhoun was angry because they wouldn't stick with him and keep filibustering. But I raise all that just to say that I think what we are facing as an institution in the Senate is its own sort of crisis of legitimacy. The filibuster has changed dramatically from what it used to be. I do think there was a brief period of time from sort of the late 1960s through possibly the 1980s where it did serve to facilitate compromise. And the reason it did that was that in any given negotiation, you could generally assume that both parties were approaching the table with a desire to move forward and a desire to reach compromise. And so the act of forcing you to get a supermajority, to get 60 senators instead of a bare majority, forced you to work with the other side. But that was a unique period in history. What you had during that period in history was the filibuster coming into more common use. Prior to then, up to 1964, with the passage of the Civil Rights Bill, the filibuster was used very rarely and exclusively against civil rights bills in terms of actually stopping bills. Every other bill besides civil rights bills that ever encountered a filibuster up to 1964 eventually passed, and usually within a relatively short time frame. So after 1964, the filibuster becomes sort of sanitized like a generic drug. Its use becomes much more common. It does facilitate compromise to a certain extent, but this was also a period where partisan polarization had not fully set in to the extent that it did today. The idea that conservatives are Republicans and liberals are Democrats was not true back then. The most conservative members of the Senate through the 70s and 80s were Democrats in many cases, primarily Southern Democrats in segregationists and former segregationists. So in a period of low political polarization, where there was not as much of an incentive to just screw over the other side, the filibuster could facilitate compromise for sort of this several decade period. What we have now is a situation where the filibuster does not facilitate compromise. It gives the minority the ability to block whatever the majority wants to do. And Alan is absolutely right that I certainly wish, I don't really wish, but if you could wave a magic wand and give Democrats the ability to filibuster Barrett, that would be great. However, I do disagree that if anybody thinks that Mitch McConnell would not have gone nuclear, even if Democrats hadn't gone nuclear in 2013, that Mitch McConnell would have just sat back in 2017 when Republicans controlled every branch of government and let Democrats filibuster Donald Trump's nominees, including his judicial nominees, without going nuclear himself. I think that is a proposition that stands against a lot of evidence of McConnell's own record. So it is true that norms are being broken and things are being reformed, but I think what we're seeing is the Senate going through a period of reform here. And I think the outcome will probably be a reversion to something closer to what the framers envisioned in the first place, which was a place where the majority, when it got the votes, could enact its agenda. It's a shame that we had a time when the people in the minority were Mitch McConnell and enacting the agenda of Donald Trump. It's a shame that when they have a majority of the Senate, they don't represent a majority of the country. But hopefully that will shift in November. From my perspective, I know that's not the perspective of the organization. But at that point, I think it's on Democrats to enact the sorts of reforms that will prevent those structural imbalances from continuing. Things like extending statehood, things like court reform, things like automatic voter registration to make sure that all the people in this country who are able to vote can vote. So that's a different perspective on the role of the filibuster. It did at one time in a brief period promote compromise. I don't think it does that anymore. I think right now it gives the minority the option to shut down whatever the majority is trying to do, and that is how it's wielded. To your question about the specific procedural tools, that is one reason why I think these tools should be deployed now, because we are sort of facing a legitimacy crisis, both for the court and for the Senate itself. I think Democrats have a lot of ground to stand on in saying this is a sham process. We don't believe that this is a legitimate use of the Senate's advice and consent powers, and we are going to use these tools to demonstrate that, not just with aggressive tweets and aggressive statements, but we're actually going to use the tools to show with our actions that we consider this process to be illegal.
Any response from any of the other panelists?
I just would say, in terms of kind of upcoming things to watch.
Let me take a stab at it. Go ahead, Leslie.
No, I was just, it's not so much in response to what Adam said, so maybe you want to go.
Well, I present myself as a defender of the filibuster, but I don't defend the frivolous filibuster. And I think what Adam is saying and the legitimate criticism of the filibuster writ large is that it's now used routinely for everything. And that's a shame. That's an abuse of a tool. To my way of thinking, that tool was useful in theory to prevent rash decisions on monumental questions. And the unfortunate situation that you all find yourselves in now is you are looking at what you believe to be a monumental question adding this particular nominee to this particular court at this particular time under these particular circumstances, a good argument could be made that this is exactly the situation for which the idea and the concept and the use of the filibuster is justified. So sure, it was abused, it's been abused, and I said this to Adam, and I said it to this panel generally. Harry Reid was provoked, and he was provoked to an extent no other majority leader was provoked, and that was the Republicans doing in filibustering a tremendous number of nominees, in preventing the president from filling seats on the DC Circuit Court of Appeals. And the president at the so-called debate the other day was taunting Joe Biden for having the Obama administration leave him with all of these court vacancies. Well, my goodness, how did that happen? It happened because the Republicans blocked them.
So let me turn back to Leslie.
Leading to another.
Sorry, Alan, I didn't mean to interrupt you.
No, that's fine.
But I wanted to make sure, Leslie, you got your point in as well, because I do want to turn to audience questions as well with a few minutes that we have left.
Sure. I just wanted to say, you know, the first thing to watch is what happens with the hearing and the vote in the Judiciary Committee. And the committee has different votes, different rules from those on the floor. And so, you know, you have the hearing starting on Monday. I think it's supposed to go for 4 days, after which senators can ask written questions of the nominee. And there are usually many, because this is a Supreme Court nominee. Those questions are then submitted back to the senators, and there's a, you know, full review. The nominee will come up for a vote. And I think the first thing to watch for is what the Democrats do at that vote. There is a requirement in the Senate Judiciary Committee that the members be present. They cannot Zoom their vote. They can participate remotely for the hearing. Lindsey Graham, Chairman Graham has already said that that's available, and so we don't know who exactly is going to do this. I object strongly to that. I think this is a Supreme Court nomination that should be, you know, in public, in person, with all the senators there. That can't happen right now because of COVID. So I think that it should be canceled, but nevertheless, they're going forward with a semi-remote hearing, but the vote can't be remote. The members have to be there. And in order to vote, they need a quorum. And that means that 12 of all 12 Republicans need to be at that vote. And if they cannot be there for any reason, including COVID, then it's going to be very interesting to see what happens, because if the Democrats don't show up, they won't have a quorum and won't be able to report the nomination to the floor. Probably Adam knows more about, I think that there's supposedly a vehicle by which Mitch McConnell can actually pull the nomination from the committee without a vote. I've heard of that discussed, but that's the first thing to watch and the first thing to see what happens with that Judiciary Committee vote.
So thank you. With that, I'd like to invite any of our watchers, if you're interested, please use the Q&A feature to send any questions that you might have for the panelists. We already have a fair few that were sent to us. So, and I want to make sure that we talk about these because there's a lot of interesting ideas that are expressed. So one quick one that I kind of had right off the top of my head, that feel free to answer it in a 2-word question, but one of the rules in the Senate Judiciary Committee is that 2 of the members present have to be Democrats, or at least of the minority party have to be present to vote anyone out. Now, is this kind of a, if you fail to object, you waive the rule kind of rule, or is it not? In other words, does a Democrat have to be at the meeting to object to moving forward without 2 Democrats present? Or if all the Democrats stay home, will that rule still be invoked?
Alan, should I give it a shot? You tell me if I'm wrong.
Go ahead, I'll tell you if you're wrong.
Okay. I mean, my understanding is that it's sort of a yes and no answer, where I believe the standing rules of the committee say that two Democrats have to be present for there to be a quorum. However, a majority on the committee can basically suspend the rules and do whatever it wants. Republicans recently did a similar version of this in the Environment and Public Works Committee, where they suspended the rules to vote out Scott Pruitt's nomination as the head of EPA. So I think it is potentially worthwhile for Democrats to deny a quorum if you're in the vein that I've been talking about. I'm not saying this would be something Alan would recommend, but if you are looking to find ways to demonstrate on the record that you consider this process to be illegitimate, denying a quorum from the judiciary and forcing them to take steps to get around that would be one way you could demonstrate that in actions and not just words.
Is he right about that, Alan?
Well, committees are free to make their own rules, and for the most part, committees are free to ignore their own rules. So there's no way on the Senate floor committee rule. There is one aspect of the Senate standing rules, and it's Rule 26, paragraph 7, A1 and A3, that requires, in order for a committee to report a measure or matter, an actual physical majority of the committee must be present. This gets back to what Leslie had started to say. And so if any of the Republicans, and the last time I looked at Judiciary, I saw 12 Republicans and 10 Democrats, 22-member committee, which means that you need to have 12 members present when the committee votes to order out anything. And this is the only rule, the only Senate rule that's really applicable with respect to how the committees operate. So in fact, if the Republicans have one absentee, they will use a physical majority unless for some reason the Democrats are willing to cooperate with them, and I can't imagine that they would. That's the one rule, it's the one aspect of committee procedure that's enforceable on the Senate floor. So yes, committees can require that there be 3 members of the minority present, but there's nothing in the Senate standing rules that enforces that. It's up to the committees to enforce that particular committee rule. But the standing rules look at the committees and say, the only thing we care about in terms of process is that when you took a vote to order this question out, you had an actual physical majority present in the room at that time. And given the numbers, if there's one Republican absent, they cannot go forward unless the Democrats somehow show up.
I have a question for Alan here. So in the Senate, there are different types of majorities. There are majorities of, in the Senate, it's Senate's sworn and serving. So that's, it has to be a majority of 100. And then there are majorities of senators who show up for a vote at a given time. So basically a sliding scale where a majority is constituted based on the number of people who show up. So with the former scale, a majority is always 51 because there are 100 senators serving. In the latter scale, a majority, if 75 people show up, then the majority is 38. So Alan, the rules for committees would be a majority of the standing members of the committee, not however many committee members showed up for the vote. Is that correct?
That's correct. As I looked at the Judiciary Committee, there are 12 Republicans and 10 Democrats. It's been a while since I took math, but I think that's 22. And it doesn't say half, it says a majority. And a majority is more than half. And so more than half of 22.
12.
So every Republican shows up, they have the requisite number. If any Republican is absent, the Republicans by themselves do not have the requisite number to order the nomination out.
So let's turn to one of the questions we got from the audience, which is that we've been spending a lot of time talking about the Senate, but what role can the House play in this process since the House has a Democratic majority? The issue that was brought up, and this is something I've heard in the media as well a little bit is the issue of the House sending over an impeachment resolution that the Senate would immediately have to take up, and forcing the Senate to spend time on that instead of the nomination. I'll throw that out to the panel to see if folks have any thoughts. I can think of several downfalls right off the bat, but I'd like to let you guys.
In a word, there's nothing to it. It's a non.
Sorry, Alan, I think you cut out. If you can just repeat the last thing you said.
I say there's nothing to that. The Senate's impeachment rules do require that when a message arrives from the House that they have adopted articles of impeachment, that the Secretary of the Senate must immediately notify the House that it will receive the managers on the part of the House to exhibit the articles of impeachment. However, the rules don't say when the Senate will receive the managers on the part of the House to exhibit the articles. Number one. Number two, once that action occurs, the Senate is quite free to terminate the trial really on a quick vote. So the details of any impeachment trial rest with the majority. And it's inconceivable that this Senate majority would permit an impeachment trial to interfere with any business that it doesn't choose to, that it wishes to prioritize. So I just don't see that that idea as being salient.
Yeah, I agree with Alan. We went through this during shutdown fights and definitely battles. There's really the rules that apply to the interaction between the House and Senate can sort of force one body to pay attention to the other in at least a passing moment. The rules don't want to let the Senate ignore everything that comes over from the House and vice versa. However, that's basically where they stop. And beyond sort of an acknowledgement that something has been sent to you from the House or something has been sent to you by the Senate, you don't really have to do much after that. And a willing majority, and it gets back to the point that if there were not a majority of Republicans who would vote to basically dismiss the impeachment trial, that would be one thing. But when you have a willing majority marching in lockstep behind the leader, the Senate can easily dismiss things like that. The one caveat I will say is that that the way this is going to play out time-wise, it looks like, is that Judicial will do its hearings next week. There'll be a bit of a delay after that, but basically the nominee will be reported out to the Senate floor sometime the week of the 19th, potentially, let's say October 22nd, could be the day. I think a initial goal for those of us who are interested in denying this nomination is to get it past the election, because I think that the dynamics after an election can change in unknown ways. Senators may feel differently about their political prospects. They may feel differently about their political calculations. They may not, and there's a whole lame duck period leading up to January where they still have an opportunity to confirm the nomination. But I would definitely think that getting the vote past the election would be an initial, at least tactical victory for the opponents of the nomination. So all that is to say that if the nomination is getting to the floor on the 22nd, and the election is on the 3rd, anything you can do to buy yourself time in that period should be on the table. As Alan said, going through all the trouble of impeaching, say, Bill Barr and sending it over to the Senate, maybe delay it by an hour or two. However, with that short a time frame, you could find yourself in a situation where delays of a few hours here and there, if wielded properly, could be very effective. I don't want to give anyone false hope here. I think it would require a lot of other breaks to go Democrats' way for that to be a viable scenario. But you could find yourself where you're down to a matter of days. And I think at that point, you probably only find yourself in that scenario if Democrats caught some breaks. So some of these other extraneous options could come into play in that sort of a scenario. Although I, again, don't want to say that it's likely, because I do not think it is.
Thank you. I would make a note, since we are past 8 o'clock, I do want to thank our panelists, since this was originally scheduled to be a 7 o'clock to 8 o'clock panel. All of them have been very generous with their time in staying on after 8 o'clock. I will say, if you're open to one other question, because we've gotten this question from 3 people at this point, which is regarding the interaction between COVID and what happens in the Senate Judiciary Committee. Specifically, we've gotten related questions to the extent of, if the Republicans fail to get all 12 GOP senators, can they change the rule that requires a majority to be present to vote out the nominee? Or alternatively, could they replace the senators on the committee in an effort to get a majority on the Senate Judiciary Committee to show up? So I'm going to throw those 2 out to the group and see what the thoughts are.
I'll take a stab at that. The rule requiring an actual physical majority is a standing rule of the Senate. Number one. Number two, senators are placed on committees by adoption of a resolution. And I believe the resolutions to do that are debatable and therefore subject to filibuster. And so under current acceptable practice, I do not see a way of replacing members of the committee without some minority buy-in, number one. Number two, I don't see a way of amending the standing rule, Rule 26, paragraph 7, which imposes the majority, which imposes the physical majority present to take that action unless the leader decides to expand the nuclear option to cover that procedural situation. And should it come to that, then the Senate has no rules whatsoever.
I would only amend to that if push came to shove, I could see Senator McConnell, what Alan is talking about is, basically several nuclear strikes in quick succession on the Senate rules, having a majority vote change the rules. I think that, if McConnell, it's an interplay between the action and having the votes to do the action. If the caucus, if his conference was game for it and he had the votes, I think that confirming this nominee is of such enormous value to him. I think judicial nominees are essentially his primary legacy. He doesn't have a lot else because they didn't pass much legislation under his time as leader. I think that he would try to get the votes to do that, and if he had them, I think he would do it.
Thank you. Leslie, did you have any?
Yeah, I just wanted to say something, kind of along the extraordinary line that, we've got a situation where senators themselves are now infected by COVID-19, and yet at this very same time, the advocacy community and, in fact, many Americans want the Senate to actually focus on COVID-19 and pass that relief bill instead of fast tracking a Supreme Court nomination before Election Day. And so it's just, if you think about it, the very thing that is, kind of priming our conversation about whether they will have their quorum, the opportunity cost argument that we're making, that the Senate should be doing what the American people need in terms of relief, and particularly with respect to Black and Brown communities who are suffering, the harshest impacts from COVID. This is something that, we're continuing to talk about. And finally, I want to say, Adam had talked about the kind of the political arguments that are different from the procedural ones. And that's something that we're very invested in. We are, trying to prevail upon senators, particularly those who are very vulnerable right now in their Senate races, to see the light, to do the right thing here. I think this is very difficult for some of them, both within their states and just kind of the national conversation about what's going on and how rushed this is and how obvious it is for the reasons that we have all mentioned about trying to pack the court to decide the election. So I think the Tom Tillises of the world, the Joni Ernest, the Lindsey Grahams, who are all on the committee, are feeling a lot of pressure right now. And we just want to keep it up and hopefully catch a break and find some, or enough people who will peel off and join Lisa Murkowski and Susan Collins and kind of save the day and not have it before election day. And we can then, reconsider and take it up afterwards. We certainly are taking the position that we don't think anything should happen till the inauguration of a new president and the installation of a new Senate to decide any of this. But we're kind of taking the battle in stages, but we certainly are trying to convince many senators to join our view on this.
Thank you. And I think on that note, let's call it, I want to thank in particular all of our panelists for taking the time to be here. All of them are incredibly distinguished and incredibly busy people. So I know that for them to take the time to chat with a number of lawyers watching to just have a conversation about Senate procedure, it was just an incredibly generous thing to do. So I want to thank our panelists in particular. I also want to extend thanks to our co-sponsors. I specifically want to call out the ACS Los Angeles chapter, the ACS San Diego chapter, ACS Oregon chapter, ACS Bay Area chapter, the ACS at-large chapter, and the ACS Madison chapter for co-sponsoring this panel with us. And we will, at this point, call it. If any of the panelists have any parting words, I'll open the floor for you to do that.
I mean, I feel obligated to offer a note of optimism in closing, which is essentially that, I mean, and Leslie was talking about the political process. I think the political process is the salvation here potentially. It is the way that the votes will be flipped. I think in combination with an aggressive use of tactics, but ultimately it comes down to the politics to flip it. And if that is not successful in taking back the Senate and putting it in the hands of people who will enact the types of reforms that will ensure that we don't have a situation like the one we're living through right now, where you have laws being acted that bind the majority of our very diverse, soon-to-be majority-minority country, having those laws be enacted by people who represent not just a minority, but a pretty monolithic white conservative minority. I think that the bigger fear here, we're seeing that the legitimacy of the court called into question of the Senate. I think that the bigger fear is that this is not a healthy dynamic. It is something that needs to be fixed. So while this fight, we're fighting and it could end in Democrats' favor, I would just hold up the example of the ACA one more time to say everybody thought Republicans were going to jam through ACA repeal and were guaranteed success there, and they failed. That could happen here. But if it doesn't, the backstop is using the democratic process and the political process to put people in power who will enact the kind of structural reforms that are needed to fix this unhealthy minority rule dynamic that we have going on right now.
Thank you, Adam. Any final thoughts from Leslie or Alan?
Yes, I'll just say thank you. I heard all those wonderful ACS chapters identified. Every lawyer should be engaged on this. Everything that we hold dear is on the line. I'm sure you understand that. But there is an assortment of things you can do. And I would just encourage you to, stick with it, and let's see what happens. I have been pleasantly surprised a number of times over the years. And so we fight to the finish. We, leave everything on the field, and sometimes we prevail. And so hopefully this is one of those times there's just too much at stake not to give it all we've got.
Thank you.
I really have nothing to add other than thanking you for inviting me to join the panel, and wishing you folks good luck.
Thank you. And on that note, we will call it a night. I encourage everyone who has questions to continue looking at the ACS DC chapter Twitter and our social media for our further events on this topic. This will not be our only rodeo into discussing the Supreme Court nomination process. We hope to hold many other informational events focused on helping improve public understanding on exactly how the process works and exactly how it's worked in the past. So again, thank you to the panelists, and have a good night for everyone. Thank you.